kia. Mai te pai maunga, raro ki te tae. Mai te awa tonga, raro ki te awaraki. Tēnei te hapori, awhia e whakatahi. Wano, hara mai te toki.
Hori e, tae ki e.
Mai te pai maunga, raro ki te tae. Mai te awa tonga, raro ki te awaraki. Tēnei te hapori, awhiai e taratahi. Wano haere mai i te toki. Hui e tai ki e. Kia ora.
Hello.
Anyway.
Good morning, everybody. Welcome to hearing stream number 4 on the Maori Purpose Zone. My name is Ann, and I'd firstly like to thank everyone who's present today and wonderful greetings and welcomes. I bring with me a group of 9 commissioners who represent the entire Wairarapa, and also the planning staff of the 3 councils, Artitan, South Wairarapa, Artitan, and the planning staff from Bopamiskil. So thank you for your presence. Did you want to say a few words?
Thank you.
No. Are you okay? Oh, thank you. Good. Okay. We'll crack on in. As I said, this is hearing stream 4. It's dealing with the Maori Purpose Zone. We have a 42A report prepared by Mr. Hamish Wesney, and also his one of his colleagues who's online, I think, Morgan Fellowfield. Welcome, Morgan. The way we'll undertake proceedings today is that we'll hear first from Mr. Wesney. He has a summary statement that he will prepare. I've got a few things that I'd like Mr. Wesney to cover off, and we'll go through that in a moment. And then we'll move to the various submitters that have asked to be heard today. Not sure when that'll take us. That may take us up to lunchtime. If it does, then we'll break for lunch and we'll hear from Mr. Wesney at the end in terms of the follow-up matters. If things proceed a little bit earlier, then we'll undertake that summary prior to the lunch adjournment. Yes, just before we start hear from Mr. Wesney, I think it's only proper that we introduce ourselves. And can I start with the Deputy Chair on my right?
Kia ora tātou, ko Robin tōku ingoa, ko Cherry Campbell tōku whānau, ko Tararua Timonga, te mangata rere te awa, no Taratahi Aho, tēnā koutou katoa.
Kia ora, Brian Della, Carlton District Councillor, Hearings Commissioner.
Tēnā koutou e te whānau. Ko Joe Hayes tōku ingoa no Rangitane me Ngāti Kahanunu oku iwi, kia ora rā.
Kia ora, ngā mihi ki te whare, ngā mihi ki te tangata o te whenua. Ko Kiriana tōku ingoa, he kaimahi o te iwi o Ngāti Kahanunu, tā oa ko Rangitane.
South Wairarapa District Council. Brian Jefferson, representing South Wairarapa District Council.
Nora Fraser Marmon, representing Marsden District Council.
Thank you, Craig. And we have one apology, Craig Bauer, who's out of the country, I believe, today. Thank you, everyone. Hamish, we'll start with you. You've got a summary statement, which I'd like you to take us through, but in doing so, I think it would be useful if you covered off a number of matters along the way, starting with how the operative district plan deals with Maori land, or doesn't deal with it. Secondly, how the Maori purpose zone has evolved between the commencement of the review of the combined district plan some 3 years ago through to the draft plan, and then what happened between the draft plan and the proposed notified plan. In terms of mechanics, it would be useful to know how the Maori purpose zone operates. You've said in your summary statement and in your 42A that it's a standalone zone. It would be useful to understand how it relates to other chapters in the district plan, particularly district-wide rules and also subdivision. Also, there's been some discussion through submissions on the degree of consultation that's occurred, and it'd be useful if you could touch on that, maybe when you're talking about the evolution of the zone. Final issue is one that you've covered in your 42A and in your summary, and one that's been raised by Maori trustee is whether there's a need for a definition of Maori land. So they're the 5 particular matters that the panel have for you.
Sure.
How you intertwine that, I will leave that up to you.
I'll ad lib as I go through the statements on those 5 matters of that way to deal with it. So this introductory statement follows the same form structure as the other hearings. So I'll read it and then I'll bring to your attention when I ad lib to respond to those questions you've just asked. Paragraph 1. My name is Hamish Resney. I'm a consultant planner at Boffinma School, engaged by the 3 district councils to assist with the district plan review. I've been involved in the district plan review and proposed district plan since the commencement of this work in 2020. I prepared the Section 42 report for the matters relating to the Māori purpose zone. So during the review of the operative district plan, Tangata Whenua expressed a desire to occupy and use Māori land within their ancestral rohi in order to develop social, cultural, economic and or environmental outcomes in accordance with Mataranga and with tikanga. Tangata Whenua also expressed the aspiration to encourage people to return to their ancestral land, and that connection with ancestral land was traditionally through building and living on the land. So I'll just ad lib there in terms of your question on the operative plan and how that relates to Māori land. And in the operative plan, there's 4 zones, being rural zone, residential, commercial and industrial. So no Māori purpose zone. And the majority of Māori land is located within rural areas. So the majority of the Māori land is zoned rural under the operative plan. And in the operative plan, it permits rural zone, permits marae and other rural uses as you'd expect, but there's no explicit reference to Māori land or recognition for how Māori land may be used, or any other land such as marae or urupa that are not on Māori land. So effectively the operative plan is silent on Māori land, but through the zonings, customary activities and other uses are permitted through the other zones in the plan.
Thank you.
Then paragraph 4. In response to these aspirations, the proposed district plan proposes to introduce a new Māori purpose zone. The Māori purpose zone has been applied to land on which marae or urupa are located. In addition, the Māori purpose zone has been applied to all Māori freehold lands and Māori customary lands under the Te Ture Whenua Māori Act 1993. And I'd note that the district plan and the Māori purpose zone has no influence or implications on the Te Ture Whenua Māori Act and how it is administered. The new special purpose, the Māori purpose zone is a new special purpose zone as a standalone chapter with specific objectives, policies and rules. This zone enables a wide range of permitted activities, recognising the social, cultural, economic and environmental outcomes sought. Permitted activities are used to manage effects, particularly at zone interfaces, and seek to achieve compatibility with properties and activities in adjoining zones. Just ad lib now, your second question. Of the Māori purpose zone. So when the review started, we had the 4 existing zones derived from the operative plan. The national planning standards, which the new proposed plan is prepared under, lists the types of zones that you can use. That limits the names and the purpose of those zones. And one of the features of the new national planning standards is what they call special purpose zones. So if none of the other zones relating to residential, rural and so on fit appropriately, then a special purpose zone may be appropriate. And the national planning standards specifically state the Māori purpose zone is a specific type of special purpose zone that may be used if it was considered appropriate in the local context. So during the review of the district plan, the conversations with Tangata Whenua around their aspirations, which I've just summarised in my statement, it became evident that the Māori purpose zone was conceptually something of interest. It was then a matter of detail as to what the provisions applied to it were and what land it would apply to. So once conceptually it was supported, those conversations then went to those two things. And then so the provisions started the Māori purpose zone started based on the rural zone. The reason I mentioned earlier, the majority of Māori land is used for primary production farming purposes, but also for marae urapa and other cultural activities. Through a number of hui with representatives from Rangatani and Kapanunu, the content of the Māori purpose zone evolved over about 18 months, which led up to the non-statutory draft district plan. And the Māori purpose zone chapter was included in the draft district plan when it was released for community feedback. But one key difference in the draft plan compared to all the other zones, the maps did not show where the Māori purpose zone applied. At that point in time, there was still discussions about what is the appropriate land to apply the Māori purpose zone to. And one of the key questions that was being discussed at that time was what was referred to as the opt-in or opt-out process. So that was where, if it's Māori land under the Te Ture Whenua Act, should the Māori purpose zone apply automatically to that land because it was considered as appropriate and it enabled the use of that land for purposes, or should it? So that would be the opt-out process. So all Māori land would be zoned Māori purpose unless a particular property owner said, no, we don't want it to be applied to our land. We'd rather be zoned another zone, such as commercial or rural or whatever. And then there was the opposite option of the opt-in. We know land was zoned Māori purpose, and that landowners would have to specifically request it through an engagement process that the councils would have with the landowners. So through the feedback on the draft plan, there was divergent views or mixed views around the opt-in, opt-out approach. A number of people could see the benefits of applying the Māori purpose zone, but also there was some concern about what implications it may have. And it seemed to be that the fear of the unknown would be how I'd describe what's it. Yeah, is it giving us rights? Is it taking rights away? It's just some uncertainty expressed about that. And there were some refinements of the provisions as well. So then into the proposed plan as to what's before you today. The provisions, I was calling fine-tuned from the draft plan to proposed plan. There was general support for their direction, and a decision was made to the opt-out process, which means that all Māori lands were zoned Māori purpose unless some landowners requested it be removed. And at the time of notifying the proposed plan, no landowners requested that the Māori purpose zone not apply to their land. So all Māori land has been zoned multi-purpose in the district plan, or the proposed plan as notified.
And I just get some clarification there. So the draft plan had the concept of and the details of the Maori purpose zone, but wasn't shown spatially on the planning maps.
Correct.
Okay. The proposed plan did show land as zoned.
Yes.
How was that landed? Was that based on the definition of Maori land under the Act, or with the opt out applying, or was it through direct responses that had been received?
It was based on what's defined as Māori land under the Tutu Whenua Māori Act. That's customary Māori customary lands and Māori freehold land are the two categories the Māori purpose zone have been applied to.
And any land that had order marae or
Yes. That's not of that status.
Yes, that's not of that state. No. And so the chance to opt out was through the submission process to the notified plan, was it?
Yeah, look, it was through the settlement, the post-settlement entities. It was asked whether there were any, for landowners, if there were any particular requests to opt to be zoned multi-purpose.
This was prior to notification.
And no requests were received.
And so then the next opportunity to opt out was through a submission to the plan.
Correct.
Yes. And I'm sure you'll get onto this later on, but you've also referred to a future process over the next 3 years where the council might, I think you've said the council was prepared to process and notified plan changes for any opting out or opting in, presumably.
Correct.
Did you want to elaborate on that at all?
So that would just be one of, there's a few submissions on the proposed plan there where there's still uncertainty about what it means, both positively and negatively for sector landowners, and also for groups of landowners for different blocks haven't had the time to have a conversation amongst themselves. So that's what that time frame is providing for.
Discussion.
Correct.
Analysis.
And so what the councils are indicating that acknowledging landowners want to have those further discussions amongst themselves, that if we have a time frame which we're saying is 3 years, that in 3 years' time, if the requests were received from landowners to change from multi-purpose zone to another zone, or vice versa, want general title land or other status of land to be rezoned to multi-purpose, councils are committing to a plan change in 3 years' time to undertake that.
Thank you for that.
And probably just highlight your question in terms of the evolution of the multi-purpose zone. Also asked about consultation that was undertaken. So the consultation or engagement with around the multi-purpose zone was initially with the EV entities or the EV organisations, the mandated organisations, with representatives of them, and then I need to check my exact notes, but there were then a series of hui held with invitees from Māori landowners across the Wairarapa. So there were, I think, four hui in total over a period of about 6 to 7 months to discuss conceptually what is the multi-purpose zone, and then have conversations around the opt-in and opt-out. That was everything I was cover on the evolution. Any questions on that?
Just check. Anything further? No, that's
Next question, and paragraph 6 also applies here. Was your question around how does the multi-purpose zone work? So the multi-purpose zone works in the same way as all other zones in the plan. So identified land on the planning maps, which is owned multi-purpose, then the multi-purpose zone chapter provisions apply to that land, and that applies specific rules to that land. Has the list of permitted activities. So able So paragraph 6 and over to page 2 as well. It summarises the activities that are permitted and activities that require consent. As I commented earlier, the multi-purpose zone is based on the rural zone. So if you compared this list of activities to the rural zone, most of them will be same activity status and the same types of activities listed, and the standards in terms of heights, setbacks, and so on. It's the same parameters there.
You're saying it's mainly in the rural zone.
Yes.
What's the effect of redefining Maori sort of land urban setting?
So in the urban setting, it's probably the 3 bits I was about to highlight. So midway down on top of page 2 in the table there, the last 3 permitted activities, which are education facilities, community facilities, and healthcare facilities. That's the key distinction between, say, the rural zone, the purpose zone, but also other zones such as the residential zone in terms of urban land, that this zone is permitting those 3 types of activities, given the nature of how Māori land and other land is used. The implication for urban zones Māori land is it would permit a wider range of activities than you may typically expect in the urban area. But because of the nature of the land, that's considered appropriate.
Just on there, Hamish, are you able to point to the non-rural land that has been zoned, Māori purpose zone? Must be some distinct blocks.
It's few. And just one thing that's unhelpful, you may have noticed with the Māori purpose zone, under the national planning standards, all special purpose zones have the same colouring. So the Māori purpose zone and the future urban zone are the same grey.
On David's question there, what's to stop, if we don't have a definition of what Maori land is, what's to stop the purchase of new blocks, whether urban or rural, and then redesignating them as Maori land?
So that would be that future process that would then look on a case-by-case basis. What's the appropriate zoning to apply to that land? And it's the Māori purpose zone.
That then has an ongoing effect on the ability to rate or otherwise of that land.
I'll come back to you on that question in terms of the implications of zoning relating to rating as well, because I'll come back to you on that question.
Thank you.
But what you're saying is that for the land that's not currently Māori purpose land, it needs to go through a first scheduled process of plan change. One way of doing that is the council's offer to do a omnibus type plan change to include additions and deletions sometime between decisions on this plan coming out and in the next 2 to 3 years.
Yes.
Okay, that's one option. Presumably private plan changes could also be undertaken.
So I'll just join the call so I can share my map with you.
Can I ask a question?
Yes, please do.
Yeah, I've got a question. Say we have a Māori purpose zone area that used to have, so it's a new kind of area, and it used to have commercial activities on it, and the group, whānau group, wanted to reinstate that they would come under the commercial, whatever is required under the normal law for developing a commercial business. It wouldn't, the Māori purpose zone wouldn't over.
No, so if I'm understanding you correctly, the Māori purpose zone would allow that use if it was within one of the listed permitted activities. Otherwise, it would require resource consent for that land if it was to re-establish.
Okay.
that's one example of Māori land and Māori purpose zone where it applies in an urban context, and it's on the edge of the urban context. I'll just zoom out into the Henley Lake and Marston at Te Orewa Road. There's a block of land here which is zoned Māori purpose. That's in a residential, I'll describe it as in a residential area on the edge of town. But there's very few examples where there's Māori land and Māori purpose zone therefore applied in urban areas currently.
Do you happen to know what the activity is on that?
I do.
Yeah.
They're looking to establish here on the right there.
So, any others that spring to mind?
Not right. I've got a few others in mind, but not, yeah, I need to double check first.
Okay. So that's an example of a non-rural zone, a residential zoning that's being rezoned Māori purpose to facilitate the development of a marae in this case. Okay.
And then continuing how the Māori purpose zone works in practice. So it's, I said about it's the same as any other zone, and therefore the relationship with district-wide chapters and rules is also the same. So if there's a site of significance, a heritage building, flood hazard, whatever is covered by those other district-wide rules, they apply to the Māori purpose zone the same way as they apply to any other zone in the plan. No, there's no exceptions or anything else. Māori purpose zone.
So noise standards, lighting standards, fragmentation standards.
Yes, yep, they apply in exactly the same way.
Yes.
And in terms of subdivision, there is a difference there. So if it's Māori land, it's defined under Te Ture Whenua Māori Act, and it's held as Māori freehold land or Māori customary land, then the RMA and the district plan subdivision provisions do not apply to that because there's the subdivision provisions under Te Ture Whenua Māori Act that apply.
Okay. So can we call that as a sort of a carve out, if you like? But presumably that's not new.
So that's existed since the RMA and the Te Ture Whenua Māori Act came about in the
1991 and 93, I think. Yes.
The one I'll highlight is if there is any general title land that is zoned Māori purpose, so it's not Māori land under Te Ture Whenua Act, then the district plan provisions in the Resource Management Act would apply to subdivision of that land because it is general title, it's general title land. So that's why there are subdivision provisions for the Māori purpose zone in the district plan. It's to cover for that eventuality.
Yes, Hamish, can you envisage on a 3-year for a time frame we've got for to discuss this? You see a lot more issues around that land where it is, where it sits.
Don't know, to be honest. I think I reflect on the various who I've attended over the last couple of years. There's mixed views, and I think some of it was just getting people to understand what the district plan and the Māori purpose zone, how that applies and how that works, and how it benefits because it's more enabling in another way. But I think it all depends on what is the aspirations of the landowners. If they have particular aspirations that better align with a rural zone or a commercial zone or industrial zone, I think that will be the primary driver for those conversations and therefore requests to the council.
I think the more you get the owners engaged, you're going to get a lot more of these questions. I think, we're going to have a lot more understanding what the answers are going to be, I guess.
Yep. And that's why I'm providing for that three-year period has enabled that time for conversations internally within the landowner groups to take place, and then also any interactions with the councils as well.
So that 3-year period won't alter when we sign off on this?
No, I don't think so. I think I think giving a time period is helpful because it gives people a date or by that period to focus on.
Thank you.
Sorry, just going back to the subdivision, just so I want to be clear. Is there any land that's not Murray freehold land or Murray customary land as defined under the Victory Act,
Mhm.
or not Murray Europar, not zoned, repurposed zone?
No, with the exception of the recommendation in the report for the
For one site,
one site to be rezoned, that's general title, to be rezoned multi-purpose.
yes. And there's also a soft recommendation from you on 2 other sites, subject to some clarification, the landowner. Yeah. Is that Murray freehold land or customary land?
I'd need to check.
Okay, I don't want to, and I know you're going to come back to those, you yet to deal with those recommendations yet. Okay,
But I'll just comment that including the multi-purpose zone subdivision provisions in the district plan, while there's none as notified and the one recommended now, but it's future-proofing the plan
yes,
for scenario in the future where more general title land is zoned multi-purpose.
yes. In the event that land that contains the Marae or Europar is, for some reason, and I don't know what it might be, is not customary land or freehold land, then those subdivision provisions would apply.
Correct.
But it's probably unlikely that it's not either customary land or freehold land. Okay, so it's the subdivision provisions for the Murray purpose zone are really a belts and braces should there be any land that's not fitting into those categories.
Correct.
Okay. And what are those subdivision rules? Are they more rural type rules or are they residential type rules? How would you categorise them?
Just double check. So they're similar to most of the other subdivision rules, where if you're doing any subdivision of land, it requires a resource consent as a controlled activity. But probably the key difference between multi-purpose zone compared to say the rural or residential zone is there's no minimum lot size.
Yes.
So the same approach to minimum lot size is applied to the urban zones, where in the town centre industrial zones there's no minimum lot size. You just need to demonstrate that the number of lots and the way you've sized them and designed them to layout that provides for efficient land use in the future, depending on what that land use is. That's probably the key difference. No minimum lot size.
Sorry. Okay. Thank you for that answer. And sorry, we're bouncing a little bit around, but do you have an understanding of how the subdivision process works under the Te Murray Act?
No, that's beyond my area of expertise. Haven't had experience in that particular bit of legislation for subdivision.
But essentially, it bypasses the resource consent subdivision process. And presume, does council have any involvement?
Sure. Look, yeah, we can check. I'm not aware of it, but I understand it's all through the Muddy Land Court. But
yes, is the district land register involved?
I'm not sure. I can provide you with a summary. I'm sure the Muddy Land Court or someone has a short summary for us to share with the panel.
I'm not sure where you got up to.
So that was everything in terms of how the multi-purpose zone works.
Yes.
The next is the matters raised and submissions.
Yes.
Just read from paragraph 7. A total of 30 original submissions with 105 submission points and 3 further submissions, 8 further submission points received on the multi-purpose zone. Submissions were generally supportive of the zone. Submissions in opposition were generally opposed to the default approach of the multi-purpose zone applying to Māori land. Sought amendments to this. Where other amendments were sought, they were to support specific outcomes in the zone, provide for specific activities, or change permitted levels of standards. As a result of submissions, a range of changes have been recommended and are summarised below. In the chapter introduction, inserting commercial into the list of other activities that support and or are compatible with the Māori purpose zone. Removing ancestral land from objective 1 to 4. Grid in policy 1 of compatible activities. Inserting a new standard 6, inserting reference to standard 6 for on-site services into a number of rules, which read out all those rule references. And then inserting a new rule for mining activities as a discretionary activity. And then recommendation to rezone the property at 291 Waiahine Valley Road from general rural to Māori purpose. Just to make a comment there that some of those changes are, the submitters have sought those same changes across a number of zones. So for example, the mining activities one is a common one that in all zones. That the recommendation there is no different from what we've recommended for zones. And similarly in terms of the reference to the national grid, the same recommendation. Responses to the pre-circulated expert evidence. So I've read the evidence submitted in relation to the Māori purpose zone from Mr. Hannah Thompson for the House Movers of the Heavy Haulage Association. From my reading of this evidence, it appears the same evidence was also presented to hearing stream 3 for rural zones. I consider the same issues apply for relocated buildings for the rural zones as in the Māori purpose zone. Potential effects on visual amenity and traffic. I note the same policies and rules apply for the relocated buildings in the rural zones in the Māori purpose zone and as notified. As this matter was canvassed at the rural zone hearings, it would be efficient for a consistent approach to apply across all zones. And I anticipate adopting the approach recommended in the reporting officer's reply statement for the rural zone hearings. And then on a separate note, in terms of the materials submitted prior to the hearing for the Māori purpose zone, I note I've seen the notice received from Ngātita Huiahu Hapu, Māori Incorporation, and just I have no additional comments in response to that notice. I've also read yesterday the statement that's come in from the Māori trustee. Heads up, and they might be preempting questions that the panel might already have, but just a couple of observations from myself and comment. One, in terms of the matters that are still on. The first one is adding the new objective on climate adaptation and retreats, the Māori purpose zone. I acknowledge the reasoning why the Māori trustee is seeking that objective. But I know that the Māori trustee hasn't sought any policies or rules or other methods to achieve that objective. I was interested to understand from the Māori trustee what did they consider the other provisions of the proposed district plan already would help achieve that objective, or are there mechanisms outside the district plan that will achieve the climate adaptation and retreat? So that was just an observation I made. And then I'll go to the third bit of release sought, which is the definition of Māori land. I was also interested to understand the reasoning request add that definition. The proposed plan that uses Māori land 5 times and all in introductory text of the plan, apart from one reference in one of the strategic direction objectives, which refers to Māori land. Normally, you'd only have definitions where the term is used in rules to provide the certainty for interpretation of those rules. So again, I was interested to understand from the Māori trustee why they see the need for that definition to be added and how it would be applied in the plan.
You have 2 questions. Councillor Plummer first.
Yeah, thanks very much. I'm really interested in this definition of Māori land. The plan is, as we've been told many times now, is a point in time. Without a definition, it makes it a more fluid plan, of which number of questions I and the panel have asked said that's not possible. So all of a sudden you're saying, oh, it is possible in this case, but not for everything else in the plan. And unless you have a definition, which officers can then interpret. So I'd be really interested in your comment. And when I look at the Maori trustee definition, personally, I'm quite comfortable with B, C, and D, but A in particular causes me concerns because it is an open-ended, and it could be any land that they buy in the future and so on and so forth, which could have a direct impact upon the point in time of a plan. So,
Yes.
interested in your comment on that.
No, I understand your question, and that's I'm interested in understanding why that second definition be added, because I think my only connection where that would have a material effect is in the associated definition that they're seeking for Papakainga, because Papakainga is in the and it refers to Māori land. What that would do, that those two definitions combination, where Papakainga is permitted in all zones, it would expand the application to all of the land listed in definition of Māori land. So that at that point,
I'm not sure I've sort of explained. So we take farmer who wants to on the border of one of our urban centres and says, I want to change the zoning of my land from rural to urban. They have to go through a process, and there are rules and so on and so forth around it. What are the rules and processes around to turn something from a different designation to Maori purpose zone? That I can't see any rules in the plan about that. And that's the issue that causes me the concern, because officers have nothing then to go, yes, that's a good application, or it's not. Well, I'm going to turn that application down. So where are those rules?
That's the same as a request to change the zoning of any block of land. So whether it's the first example you gave, say from rural zoned land to residential zoned land because they want to build housing on that land. So that either council would propose that as a plan change to the plan, or there could be a request from the landowner or another private person or company to rezone that land from residential. That same process and considerations would apply if someone wants to go from rural land to multi-purpose zone. It would be the same process, same considerations, and where the key parts of the plan, that the proposed plan that you'd be assessing those applications or requests to rezone land would be the strategic direction objectives. Does it achieve is rezoning that land aligned with the strategic directions? And then also, what are the objectives for the particular zone? So, and how that applies to the land. So you'd look at is that land actually appropriate for residential purpose, or is it appropriate for a Māori purpose zone purpose?
Which sort of circles back to my question about the rating implications of zoning, which I'll be really interested in.
Sorry, thank you. Around having a definition for Māori land, are you aware of any other district plans nationally that have a Māori purpose zone and include Māori land in their definitions?
Yes, yeah. It can be pretty common to have the Māori land defined in district plans. The most common approach I've seen is where it refers to the Tūturu Māori Act's definition of Māori land, which is Māori freehold land and Māori customary land. But there are other definitions, not of Māori land, but say the definition of Papakainga, where that can expand the type of land that definition applies. What the Māori trustee is seeking here for Māori land.
And just to clarify, you said before you didn't feel that there was any need for us in our proposed plan to have a definition because we don't mention Māori land under rules in our MPZ. Okay.
Any
or any other provision. Yeah.
Any other rule in the plan.
Okay. Thank you.
That often, and there'll be more discussion on this later. Would the absence of a definition of Maori land preclude rezoning of in the district plan, rezoning of land either through the 3-year process or through a private plan change?
Not in my view. No.
Any further questions on the definition of Maori land? Was there anything else on the Maori trustees statement that you wanted to? When you touched on the definition of papakainga.
No, not at this point in time. Okay. Everything. So then the last part of the hearing introduction statement was just those matters in contention, which I can read out if you like. I'm happy to take them as read if you're happy with that as well.
Yes, that's fine. We'll just see if we've got any questions on your 42A report, or were you going to, is there anything you wanted to?
That was the introductory statement.
Panel, any questions to Mr. Wesley on his original 42A report, the 37-page report?
Do note that you actually reference a couple of times on some of the submissions about submitters wishing to elaborate at the hearing on, yet they're not scheduled to hear. So that's unfortunate that they can't elaborate on that. Yeah.
Yes.
Yeah.
Joe.
Opt in, opt out, 3 years, the council or whānau to sort out whether their land's going to opt in or opt out. Once the 3 years is up, is the decision locked in for life?
No. So it can change at any time. So that could be through a private plan change request from a landowner to rezone. So any landowner can do that at any time. So request their zone be changed from one to another. And that would, with the current operative plan and this current process, that in 10 years' time, the councils will need to review their district plan again. So that would be again the next chance to have to look at the zoning of all the land and the multi-purpose zone where it applies.
I've just got another further question on that finish. With that opt-in and or opt-out process, I don't know if you can answer this now, do the councils see that as a simple tick box exercise within that 3 years? Nothing onerous?
I wouldn't describe it as a tick box. I think it would depend on the number of properties and the nature of those properties that were sought to be rezoned. For example, if it was rezoning some rurally located properties from the multi-purpose zone back to the rural zone that they currently are on the operative plan, and that would be, in my view, a relatively straightforward plan change, because that rezoning would be reflecting the current and future use of that land, assuming it was continued to be used for farming purposes. If there were a number of urban properties which were sought to be rezoned multi-purpose, and they were an assortment of uses or planned future uses, and depending on their context, that could be a bit more of a bit more involved in that plan change, but you'd be considering the relationship between those properties right to be rezoned to multi-purpose and what surrounds them. There could be a little bit more there. So it all depends on the number and nature of the properties involved.
Paragraph 146 of your section 42A report relating to NPZR4 Papakainga. Just at the end of it, your last sentence is saying, for completeness, I clarify land would be zoned as NPZ as opposed to rural. And again, hopefully the submitter will comment on that further. Will that need to be done as part of the rezoning hearings, or will that be part of the 3-year potential process? How do you see that?
Either.
Either, it can be either.
I think.
Right, but it's not a decision that we would need to make as part of these deliberations, so.
No.
No, okay,
I think that it's multi-purpose owned.
Yes.
Submitter is up, requesting otherwise through this process.
thank you.
Just again to clarify that, Mr. Wesley, where the scope during our deliberations and decision making to change the zoning, land zone married purpose, where the scope, we can make those decisions
Correct.
accordingly.
Correct.
Okay. And I'm just gonna go to the three matters in your report where you deal with that. Starting at paragraph 231 on page 38. This is where there's been a submission received, asking that the rural special zone, lots of it's rural special in the operative plan, and I think it's general rural in the post plan. You've given a sort of a soft signal that it would be appropriate to zone that land. To zone married purpose, and
It's proposed to be multi-purpose in the notified plan.
Yes.
And the submitters requested it be rezoned back to rural.
Yes.
And my query in the report is the individual that's put in the submission acting on behalf of the authorised act, basically on behalf of the collective owners of that block of land for that change of zoning.
Yes, and that's Mr. Gibbs, is it?
Correct.
Yes. And similarly with paragraph 233, Regan Pro Tangaroa
Correct.
also seeks that the married purpose zone be deleted from the titles and rezoned, presumably rural.
Correct. That was my reading of the submission.
Yes. Do you see the process? You've said that confirmation sought from the submitter that they are acting on behalf of the owners of the property requesting the zoning. How do you see that eventuating?
Well, this is something discussed with representatives of the post-settlement governance entities as to, what is that form of confirmation? And their advice was need to be a special general meeting of the landowners.
Yes.
There's a resolution passed by the landowners that this is actually what the collective wants. And that's the form of evidence from the landowners that there is a request or support that position.
Yes. Does this panel have a role in front footing that and facilitating that, or at least asking the question?
I think asking the question, definitely.
Okay.
Given these two submissions that are before you, yes, that's because they've come in from individuals. Just want to basically be sure that is the case, that they are acting on behalf of the collective.
Raise its assurance.
Correct.
Yes. And if that assurance is given in both cases, your soft recommendation would become a firm recommendation for rezoning.
Correct.
Okay. Well, that's something we'll follow up in terms of that sort of question, how the panel asks that question and who to. The third one is one where you've given a firm recommendation. That was a specific property. Trying to find where that is that
That very bottom of paragraph 240, 241.
yes. Yes.
Oh, yeah.
Okay.
I think there's a map in the appendix 4 showing
The Wahine Gorge.
the Wahine Gorge property.
Got it.
That's Miss Craig is coming in later today to speak to that.
Planning on doing papakainga out there.
So that's where understanding the aspirations of that trust and discussions with the EV representatives in terms of confirming whakapapa to Wairapa. That meets the criteria for applying a multi-purpose zone to a general title land.
Yes.
Because they are one of our local hapu in Arohi.
You've recommended that the submission be accepted.
Correct.
Okay.
Well, you've articulated my questions significantly better than I could.
I just got one other question. I think I know the answer, but I'll ask it anyway. what impact, if any, does the MPS HPL have on Maori purpose zone land? This is the highly productive land.
Yes.
Planning standard.
So in the national planning standards, it's I think the term specified Māori land, which include where effectively the restrictive policies of the national policy statement on highly productive land do not apply
Okay.
to that specified Māori land, and the definition of specified Māori land includes Māori land as under the Te Ture Whenua Māori Act. So effectively the MPS wouldn't apply to area where that's zoned Māori purpose as notified.
Could you formalise that in writing as part of your reply, please?
Yes, to the question asked previously about this point in time.
Yes.
Yep.
So there's a cross reference to the Act in the MPS HPL. Yes. I have one final question, Mr. Whitney, and that's one that came up at a previous hearing, and it relates to standard 6. Try and find. So some submitted asked that standard needs to become a standard to which certain rules must meet in order to be permitted activities, and where they don't, they default to either restricted discretionary or discretionary. And I was interested to see that in standard 6, in the version that I've got, clause 3 requires all new buildings must comply with the New Zealand Fire Service firefighting water supplies code of practice. Was that part of the notified plan?
Correct.
Yes.
Yep. Same as the rural zone.
Right. Yeah. Okay. So that's quite different to the urban and open space zones, isn't it?
Correct. Yeah.
Yes.
Christian has highlighted a question I had in my mind, where there's been other submissions on the rural zone standards, for example, which the Māori purpose zone standards are based on. So there's likely to be some recommended amendments to the rural zone standards in response to those submissions, but there's no equivalent submissions on the Māori purpose zone for those same, and the on-site services standard 6 is one of those examples. So I'm probably just flagging from now that there may be a recommendation for some consequential amendments
to the rural zone.
From that to align the Māori purpose zone with the recommended amendments to the Māori. That there may be some consequential amendments recommended to the Māori purpose zone to align with the rural zone.
I was going to ask whether any amendments from previous zones, and in particular okay.
It's a scope question that comes up there. So we just want to, because as I highlighted with relocated buildings, it'll be efficient to have the same rules apply across all zones. There's probably a number of other standards where that would also be efficient. So we just want to, given this is the last zone before the panel, just want to cast our eye across all the zones and see if there's the ability to align the standards to make them.
Makes sense.
I have a question.
Yes, just before you do, can I just close this one off?
Yep.
So just to be clear, in terms of the plan as notified, the rural zone and the Māori purpose zone contained this standard requiring compliance with the fire service firefighting. Were they the only zones?
Need to double check that.
Okay. Yes, but the urban and open space zones did not, but they've been subject to a recommendation for that standard to be included. Yes, and everyone will be aware that the panel have issued minute number 8, seeking some further clarification on implications of having that standard apply to residential and commercial zones, and seeking some further information from the council, a whole of council approach response to that. Sorry, Joe.
Yeah, my question's around the property at Waiohine Gorge that is obviously zoned in some other under some other zone, not Māori purposes.
Rural zone at the moment.
So Ms Craig wants to see if it can move into Māori purposes zone. Would she be subjected to the same as what other whānau that want to change from one zone into Māori purposes zone for that 3-year review, or would we do that here through the
So she's one of the, so you do it through this process for Craig's land, and that's because putting a submission to change it through this process. But it would be a similar process in the future for that, from that 3-year period, that landowners would put forward why they'd want to be rezoned from whatever zone to Māori purpose, and through that would be consideration. One, are you speaking on behalf of the collective of landowners? Two, do you have whakapapa connection to Wairarapa? And 3, what are the aspirations? Do your aspirations of the land align with the Māori purpose zone?
Excuse me, it's just that when you write this up, can you make sure you're quite explicit, because there'll be eyes that will read that, and if it's not kind of spelled out, they might think, well, why can't we get that?
Yeah. What I can, that's a very good question, Joe. What I can say is that where there's any scope through a submission to the plan that enables us to change the zoning, we can do that based on a merit analysis. We don't have to wait for the 3-year period.
No.
But where, for whatever reason, a landowner or a group of landowners haven't sought a change because for whatever reason, they get a second opportunity through the 3-year plan change process.
Yeah, it's just that when this plan is completed and is published, I just want people, whānau, to be able to read that and know, all right, so Miss Craig did this and did that, and that's how come hers was included in this.
And certainly, as authors of those decisions, we can make that very clear ourselves too.
Yeah, good. Yep.
Okay, I think we've exhausted our questions. Whitney, is there anything that you want to say in closing?
I think nothing.
Okay. We're running well ahead of time. Supposed to break for morning tea at 10:30, but can I just check who's in the room? Mr. Cooper's not online, is he? No. Manu, would it inconvenience you if you went now?
No,
No?
I'm all for that.
Okay.
And there's always been.
Just take your time. We'll shuffle our notes.
You're not going to have your cup of tea first.
I think we'll just push ahead and we can have a cup of tea afterwards.
Yes, yes.
Okay. Look, would you like?
Yeah.
If you want, it's probably easier if you come up to the front, because then the recording,
Is that a mic, is it?
yes, that'll pick it up, just for the people that are online.
Here's my bill.
Of course, just while you're getting organised, just want to record that Commissioner Daly has excused herself from during this presentation and from undertaking any deliberations in relation to that, due to a perceived conflict of interest. That entry has been recorded on the panel's register of interests. Thank you, Ruth, for doing that. Right, now we're in your hands. We've got your original submission. Do you have any further that you would like us to have a look at? Or are you just going to take us through this morning?
Yeah, no, just what's there is there.
Okay,
But
that's fine. Yeah. Okay, well, the floor is yours, as they say.
okay. Ai, kia ora tātou, tēnā koutou katoa. Ko wai au, ko rangi tīmau te maunga, ko Waipawa Tāua. Ko Ngāti Kahu Nene, ki rangi tāni o ke iwi, ko Ngāti Te Ahuahu, te hapū. Ko Akura, te marae, ko Akura te tangata, ko Akura te papakainga, ko Akura te takikainga. Tēnā koutou, ko mani tawhata, taku ingoa. Ngā mihi kia koutou te tepu i tēnei wā. Hi, kia ora. When I originally, when we went over the stuff when we were submitted, this is a memorandum of understanding. It's not a submission as such as we've heard about submissions. It's actually a declaration of Ngāti Te Awhiahu's memorandum of understanding. Now, for those who don't know where Akura is in Masterton. It's on the west side of town. We are now have the massive heavy bypass route in our area. So all those heavy trucks, all those traffic that's coming from here, coming from up north, coming from south, is now on our road in our area. So we're a little hapu. We're not, we're a quiet hapu. I suppose some could say that, except Manu, she's not so quiet. But anyway, given the fact that we've had a lot to deal with over the years concerning with the councils and concerning the iwi, concerning the courts, we've had to, find it within ourselves to either stay quiet or say something about what was happening in our area. But so here I am today.
What sort of numbers make up the hapu?
Oh, and now immediate family, maybe 150, 200.
Yes.
And it's growing, of course. And our registrations were Ngāti Kahununi ki Wairarapa Tāmaki Nui Arua Trust. Apparently we've got 234, unbeknown to me.
Okay.
I go, oh, okay, where's these other numbers coming from? But we don't know where those other numbers are coming from because we're not privy to that information because of the Privacy Act. And anyway, so yeah, so that's where we are. So this is our memorandum of understanding, and it's got all the information in there. It's got the sections of the acts that are in there that allows us to put this forward, and it allows us to be included in the decision making concerning our area. We do not allow, or we don't accept Ngāti Kahununu, either both of them, Ngāti Kahununu ki Wairarapa Tāmaki Nui Arua and Ngāti Kahununu Wairarapa, or Rangitane, to continue to make decisions on our behalf that we don't even know what decisions they're making on our behalf. So because we are actually excluded from the consultation process, because why? They're the iwi and they've got the mandate. Well, they didn't get the mandate from us. So that's why, hence why this application was made. So if you've got any questions for me, yeah, by all means, I'll answer to the best of my knowledge.
Say, Kiriana, have we got?
Kia ora.
Report by Carl, no questions. Got it.
No questions. Thanks for the email. You have read it 2 or 3 times and I understand where you're coming from.
Nothing so far. On my left,
No, just thank you for the bread.
well, Manu, I have some questions.
Yes, go for it.
I guess the main question is, and it's a question I ask to a lot of submitters, is what is the decision that you want this panel to recommend and make in relation to the Murray Purpose Zone?
Now, I didn't realise that when this Māori Purpose Zone came out, when we were going through those threes last year, and then I looked on the map and that we had already been zoned under Māori Purpose Zone. Unbeknown to us, there's another instance there that we were in a consultant that we were already opted in. So it's up to us now to opt out or continue to stay in. When we made the submission, we made it on the condition, on the provision that we are included in this Māori Purpose Zoning, or in this Wairarapa Combined District Plan, that we are included in that, and that was on the provision that we are included in that. So if we do get included in that, yeah, we'll be very happy, because it's all about us, not so much sitting at the table or having a seat at the table, but we just want to be consulted in the decisions that are being made in our area. So that's that's the main purpose of the submission.
Can I just seek some clarification from Mr. Wesley? So the landholding associated with this hapu, the suggestion of that they are covered by the Maori purpose zone?
Yes,
Yes.
from my
Yeah.
understanding.
Yes.
Thank you, yeah.
So, as notified, and you, am I hearing that you support that?
Yes,
Yes,
we do support the
Okay.
Māori purposes zoning. Provisionally,
yes,
we get a 3-year review on when this is all sorted
We do.
and dusted and sorted? So we get a 3-year review. So if it's working for okay, for us okay, then yeah, we most probably will continue to stay as we are and stay in. But then if the review is not so much working out for us, then we most probably will.
so this is the way I see it playing out.
Yep.
Based on what you've just said, you've made it very easy for this panel to confirm the zoning over your land as Maori purpose zone. And that would be reflected in the decisions that we issue next year. If you change your mind for whatever reason,
Mhm.
as part of this review, and you decide, look, it's on reflection, it's not the best thing, and we want to opt out,
Yeah.
then the process that Hamish outlined would kick in, and you'd be part of this omnibus plan change that would either add or subtract properties from the decisions that we've already made. That it's probably that simple.
Oh, well. Right, okay.
Does that sort of give you a degree of comfort?
Well, it certainly gives me great hope.
Good.
Our memorandum of understanding is going to be included in the PWCDP. Have you got a time when that decision is going to be made?
Yes, it'll be, we're going to issue all our decisions at once.
Yeah.
So there'll be 13 decision reports, and it'll be around mid next year.
Yeah, okay. No, that's,
The process is we make recommendations. It's not about decisions. We make decisions, so we don't need to report back to the councils. We have authority to make the decision. And it'll just depend on the timeframes that we've got to write those decisions up.
and that's according, if everything goes according to plan, you're looking at mid next year.
But next year.
Yeah.
I mean, we're undertaking deliberations as we go. We're on track. We're starting to write decisions on some of the earlier stuff, drafts. So things are looking good to the timeframe.
It is.
Can't wait.
No, couple of.
Thanks for attending. Now it's time for a cup of tea, I think.
Oh, is that me, is it? Oh. Oh, cool.
We'll adjourn the hearing until 10:45 and invite everyone for a cup of tea.